and tell one of the girls that you're planning on coming. We say RSVP, but it's a very, very informal process. Just what we'd like to do is have a head count. Because, Miss Tammy makes light refreshments, and I think I've said this before, the worst thing that could happen to a woman who makes refreshments for an event is to run out, right?
That's right.
That's like the kiss of death. So we like to keep a kind of a head count so that that doesn't happen. And inevitably, people can't make it at the last minute, and inevitably people just walk in at the last minute. They haven't called it off, and that's okay. Walk-ins are certainly welcome, and so are, if you can't make it, that's fine. You just can reschedule, or we'll do something else. But we just have the basic head count. Make sure we got plenty of tables and chairs and enough refreshments. But if you hadn't come to one before, you might want to give it some thought, because I get a lot of great reviews for them. People who have come to it have talked to other people and said, they learned a lot. And I'd be prepared for that. Yeah. I like to warn people, this is not going to be a free meal and a loosey-goosey sales pitch and just shooting the breeze kind of thing. This is going to be nonstop information from the minute I start talking at 10 o'clock to the time I quit, which is about an hour and 15 minutes later. And you will be surprised. That hour will go by extremely fast, and there'll be a lot of stuff you've never heard before. And that's what will interest you the most. So don't come with a closed mind and say, well, I never heard that, so I don't know how that can be.
Right, right.
I like these older gentlemen. The person in my family that just recently passed away was like that. I said, well, I never heard of that, so I just don't see how that could have been. Yeah. It's like, okay, something could exist that you don't know about. Right? And that is possible. That is possible. Have an open mind.
Well, I had a friend who said he couldn't think of nothing he didn't know.
Yep. And he was ignorant of the English language too, right? Because he only knew 25,000.
That's right.
But come with an open mind, because the things you haven't heard are the things that will interest you the most, because most people feel there's only such a limited things that they can do in estate planning. Which is right, like, you'd be surprised how many people think that a will is all you can do. This is the only choice. And it's not. There's many other things to do. And the will doesn't fit most people's plan, and so they don't do anything at all.
Yeah.
So come and hear it. There's no pressure whatsoever. If you don't like it, don't do anything. If you want to get up in the middle and leave, do so. I don't think everybody ever has, but I've had people come in late, but not. Right. But I'm saying that it's okay. I mean, it's not like we lock the door and make you sign something. There's no commitment whatsoever. I do offer incentives for people that go to that, if they want to go forward with my firm and do some planning. And I have had people call me and say they came to a seminar 3 years ago, and they say, do I still get the incentives? I say, absolutely. I mean, I say if you get it because you pre-educate yourself.
Yes.
And you come to the seminar, because if you're going to come talk to me, which I encourage, but if you want to come talk to me and get the biggest bang for your buck, go to the seminar and learn the preliminary stuff. Don't, because if you come to me and want to just have me explain to you what's the difference between a will and a trust, all the fundamentals and stuff.
Right.
The girls in the front desk will never let you pass without paying for that time.
Yeah.
So come to the seminar, learn the basics.
Yeah.
Because the reason you learn the basics is now you will start to lean one way or the other. We talk about trust and wills and a couple different kinds of trust. Now your interest will be piqued on one thing or the other. And that's what when you come to the meeting, you want to talk about. Because when I have a meeting, if you've attended the seminar, you're entitled to what we call a family vision meeting.
Yes.
And that's a deep dive into your personal family dynamics and problems you want to solve. And I offer that at no cost. And that is typically a 2-hour meeting. It's probably never less than an hour and a half, and usually not more than 2. But that's time I offer freely. But I offer it because you came to the seminar.
Yes.
And it's not so much that I give it away. I give it away for some quasi self-serving purposes.
Sure.
I don't have to go over the fundamentals. You've already got something that's got your attention, and you want to talk more about it. Right. So it makes the vision meeting so much more productive.
That's right.
And that's the thing. It's not. If you can't come to the seminar for some reason, or you've signed up and something happened and you can't come, or you can't wait till the next one.
Right. We
have a recorded version of it, and it's it's a YouTube, and it's just my PowerPoint, but with me talking. But it's about 95% of the same information.
Yeah.
So, and we offer that to people too. So, but. We get such great reviews of the live one, and you get to watch me do it personally. You get the pleasure of seeing.
Well, there's so much more you can just gather by being, present.
Well, and it's interactive, so you're kind of there. And I think the information sets better when you're present. When in days of COVID and the webinars and the YouTube things, you just drift.
Yeah.
But although the people that watch the seminars, I get a lot of good reviews on that too. They said,
Yeah.
we watched that and it was very good, and it cleared up some stuff and made things available.
Well, a lot
So-
of us are used to that too.
Yeah.
You know, we really are.
So, either way, I highly recommend it. There's no cost. I call it free educational seminar, but I like to focus on the word education. But I do it because, like I said, there's so much misinformation. There's so much non-information out there.
Right.
That you need a place to go to get some clarity as to what is out there and what's available.
Right.
And that's how the whole thing got started. You know, I had so many people come in to say, you know, I want to write a will. And I would say something like, that's great. Have you ever considered the options to a will? And it's like, I don't know what you're talking about. I thought a will was all we could do.
Right.
And so years and years ago, I decided I need to get something going that educates folks that that's not just the only thing that's out there.
Yeah.
And that's how these seminars got.
Well, you know, that's been the prevalent advice for many, as long as I can remember. You know, it seems like that was the general public advice is, do you have a will? Do you have a will? You make sure you get a will.
Yep.
You should have a will. It was preached for so long that everybody just thinks that's the only option.
And on the internet, that's the answer you'll pretty much find.
Yeah.
You know, when I first started doing this, I can't remember when it was, but the first seminar I ever held, nobody came.
Yeah.
Well, probably because I didn't understand marketing. You know, I'm an attorney, I don't know how to do that. But anyway, I think the second seminar I gave, I had like one person come, or two.
Okay.
And those, you know, but you know, things start. When
Yeah.
things start, they start.
Yeah.
And now,
That's interesting.
now we don't want now we worry about exceeding the venue's capacity.
Yeah.
So come on, you know, again, Saturday the 22nd, 10 o'clock. I'll touch on that again at the end of the hour.
Sure.
I did want to bring up something that I may have touched on or talked about. I'm sure I did, but this is a real life example of what happens when what I talk about comes back around.
Yes.
And that is, you know, I've been doing trust plans long enough that, you know, I get calls about the trust matures, meaning the people that wrote it have expire.
Right.
And now your successor trustees are taking over. And so, just a brief background, when you have a trust, you're the maker of the trust, and you have a name, it's called the trustor.
Okay.
And then you're the trust, then you have a trustee of your trust during your lifetime, that's the trustee. But at your death, when the maker of the trustor's death, now we designate someone called a successor trustee, whose job doesn't even,
Right.
their job doesn't exist until the moment of the trustor's death. And there's immediately somebody empowered to deal with the trust once the trustor is gone. Now the successor trustee's job is to take the property that's in the trust and distribute it in accordance with the language of the trust that says how it goes, right? So let's just say simple trust says, I got 3 children, everything I have goes to them 1/3 each. The successor trustee's job is to take that property, get it all together, divide it in 3s, and distribute it to those 3 children. Okay, that's their job, and that typically would be one of the children.
Right.
I mean, it doesn't have to be one of the children, but it
Right.
typically is an adult child. So those are the players. Now, a lot of people, when we're designing their trust, will ask me questions like, how many successor trustees should I have? And I would say, well, I've named more than one because we don't ever want to run out. But a lot of folks say, does it have to be just one person, or can it be people acting together?
Yeah.
And I say, oh, absolutely. You can have 2 people or 3 people acting together. Okay. I said, but if you do have 2 people or 3 people acting together, now we have to further define their authority. And in other words, if it's one person, if you name 3 people, you can have a consecutive order. Okay, which
Yes.
means the first one up is the one in power. And if he is unable or unwilling to perform, which covers just about everything, predeceasing, being incapacitated themselves, or in some cases just moving off to Switzerland and just can't do it, or even just not wanting the job. You know what I mean? You can't make somebody be a fiduciary. So,
Yes.
so it covers everything. So if that fails, if that person fails, you know, in other words, is unable or unwilling to perform, it goes to the next one in line. So it's a consecutive order.
Yes.
And that's my recommendation. And simply because from an attorney standpoint, you've got one person in power at any given time, and that works well.
Yeah.
Now, but you can have co-trustees. You certainly can. There's nothing that says you can't have it. But here's the problem. Let's just say you have 2, because that's the example I'm going to talk about. If you have 2 people, you know, 2 children, and you say, okay, I want them to act together. Okay, now we have to further define that. And here's the choices. One, you can say, okay, they act together as co-trustees. They serve jointly, but they have independent authority to act. Okay, now if you're going to name more than one, that's my recommendation, because they both have to decide something. Okay, let's just say a bill has to be paid. They both have to agree that it's paid, but it only takes one of them to make that work. One of them can fill the check out and pay it. So
Oh,
they have
okay.
the independent authority to act. The other choice is unanimous authority to act, which means both of them have to sign every check.
Uh-huh.
And that can get cumbersome. And it gets cumbersome with the banks too. If a bank sees unanimous authority, they sort of panic and they err on the side of caution, and they are unwilling. They will not let a check go through unless both people sign it.
Yeah.
I mean, if you say, "Listen, I got to pay this. It's due today. This has to get paid," they won't deal with it. Now, that's what I want to talk about, because I never recommend unanimous authority, because I have had some people that say to me, "I'm going to make all three of my kids co-trustees with unanimous authority because it'll make them work together."
Uh-huh.
It
Okay.
does not. I've never seen that work.
I can vouch for that.
I have never seen that be smooth. And not many people do it. Most people listen to my recommendation. When I tell them why, it makes sense. And
Yeah.
that's why.
Yeah.
But this case I'm trying to tell you, I remember it. About 2 years ago, a mom had 2 children, and she, after we had this very discussion, insisted there be unanimous authority. Now, I don't want to talk anybody into anything, and I don't want to talk anybody out of anything. My job is to advise, and we went over all what we just said, probably in even more detail.
Right.
And so, and I said, the unanimous authority can be cumbersome for them, depending on the circumstances. Well, she had passed away, and I got contacted by the successor trustees, and they had gone to do something at the bank, and the bank told them they needed both signatures, the children. And they contacted me and said, "Is that right?" And so a couple of years ago, so I pulled the trust up and took a look, and now I pulled my file and read my notes, and there, yes, that's
There it
exactly
was.
what happened. She named them both with unanimous authority. And excuse me, I had in my notes that we had talked about that, and that's what she wanted. So, and like I said, if you're fully advised and that's what you want, that's what I'll do, because you should be making an informed decision now.
Yeah,
Right? So,
exactly.
And so they asked a couple of questions about it, and one of them was, can that be changed? Now, I don't know what the problem is yet, and I even asked, I said, is there a problem with co-trusteeship? And kind of say, well, okay, what's the problem? Is somebody live in like Germany or something, and getting a signature is going to be hard to mail back and forth? Or do you not get along? Do you like despise each other?
Yeah.
What's
the deal?
I haven't been responded yet, but the answer to that was no. Once the trustor passes away, that trust is cast in concrete. It's irrevocable, because the only person that can ever make a change to a trust is the maker of the trust.
Yes.
And I mean, not the trustee. The trustees can't change anything. I mean, they can change ministerial things, very, very simplistic things, but nothing substantive.
Right.
So it has to stay put. And so I haven't heard back from them, but I suspect that's not the answer they wanted to hear, because they very much wanted to know if it could be changed and how to do that. Now, I gave that some thought. Actually, this was actually just yesterday or the day before.
Oh, wow.
And I gave it some thought, and because there's a provision in there for a trust protector. Trust protector is a special role of somebody, which we adopted the trust protector back in 2012, and a lot of states did, and it's a good thing to have. I'm glad we did. And I usually name myself as the trust protector in my trust. Now, again, it doesn't have to be me, but it does need to be someone like me, someone who's a professional, has to have a part in the plan. I don't take anything under the plan. I'm an independent person. Somebody doesn't have a dog in the fight.
Yes.
And a professional, and a person that knows how the trust that I've drafted for these people, what their intent was and what they wanted.
Right.
And then as a trust protector, I can fill vacancies. Let's say you name a trustee and they pass away untimely, and now that you don't have somebody, I can fill that vacancy for them. I never act as a trustee, and I never deal with any property, but I can fill vacancies. I can make corrections if the trust is ambiguous, or I can make modifications to comply with certain laws that change. There's a bunch of stuff I can do
Right.
to keep the trust working and doesn't get frustration of purpose for some reason.
Right.
And one of the things is dealing with trustees. I can remove a trustee and I can appoint a trustee, both during life and during the successorship. And so, but it's not the trust. It has to always be within the intent of the trustor.
Right.
So I thought, could I change it as the trust protector? And I thought, maybe I could, but I don't want to go that route, because I know what the trustor wanted, and it was the two of them acting together.
Sure.
But I got thinking about it, and I thought, you know what? Here's the only thing I can come up with. The trustee can always resign. Okay, now, this language said the two of them with unanimous authority or the survivor thereof. So if one of them had passed away, it's okay for only one of them to act.
Right.
But a trustee can resign. So I proposed to them, if one of you resign, the other can perform as an independent.
Oh, wow.
Now,
Okay.
I don't know what the concern is. If they're at odds, they might not want the other one doing it. You know what I mean? I
Yeah.
don't know that. But that was a thought. And then the other thought is, like, if you both resign, I, as the trust protector, can fill that vacancy with somebody else.
Interesting.
Somebody that, you know, I would talk to people and find out who would do it, you know, the fiduciary duty with, you know, unbiased and
Sure.
best interest of the trustor and stuff like that. So that's the only thing I came up with, but it's a classic example. Most people, after I talk to them, don't do the unanimous thing. I do see it a lot in wills. When people bring me their will, they name their kids and they name them all co-executors.
Yes.
Same problem.
Yes.
And it can be a problem. Now, I'm not going to say it's a problem in every situation, but I have never known it to work well. I'm going to give you another example.
Yeah.
Had a trust. Now, I did not author this trust, but it was brought to me in the administration phase. And it was actually brought to me 12 years after the death of the surviving trustor.
Oh, wow.
And brought this trust, and these folks had 3 children. Okay? And of these 3, and they named them all as co-trustees with unanimous authority. Now, these 3 children hated each other. I mean, to a level it was uncomfortable to even experience. I mean, they just despised each other.
Oh.
I don't know their history, but it was hate. I mean, it's a strong word, but it actually fits the situation.
I've witnessed it myself.
And they owned property, and the property was becoming dilapidated, and they couldn't get anything done because nobody would agree to anything.
Right.
So they came to me, they said I was like the 4th or 5th attorney they went to. And all the attorneys said, well, we made a phone call, and so-and-so won't agree, and so I'm sorry, there's nothing I can do for you. So they came to me, and kind of like last-ditch effort, I guess. And I looked it over, and I thought, well, we're stuck with it now, so we just have to deal with it. So what we were trying to do was get them all to agree that we could spend some money to fix the roof on the house they had here locally, because it was caving in, you know, and it was damaging the property because of the leaks, right?
Right.
And other restorative stuff. And then they wanted to distribute the property. They couldn't distribute it because nobody would agree on anything.
Yeah.
Now, what I did was I got a hold of them. I remember talking to the person's brother. They actually got him on the phone, and I explained the situation. I said, you know, what I was doing and what my role was, and that if we can get everybody to agree, we can preserve this property to fix the roof. Now, it is a fiduciary duty to preserve estate property. You know, that's a no-brainer there. I mean, if you're a trustee, you have an absolute duty to preserve the property. Okay?
Yes.
And the brother told me, I'll never forget his words. He said, no, he wouldn't agree. And so I asked, I said, would you please tell me why you don't agree?
Yeah.
Now, I wasn't just curious. I'm building a record, okay?
I'm trying to figure this out.
It's probably close to a bamboozle. And so it's not, I'm trying to, I know the answer I was going to get, and I wanted to get it. Okay. And I said, would you tell me why? His answer was this. He said, I'm not going to agree just because she wants me to.
Isn't that something?
Now that's hate, right? Now, what I did, I guess the other attorneys didn't think of doing, but I took that, went to court, filed a petition. I said, Judge, we have a successor trustee who's in breach of his fiduciary duty because just not doing something because his sister wanted it is not an action of a fiduciary. His job is for the best interest of the trust in the property, and he's just doing it for personal reasons. And I had the court remove him. Now, I had the court remove the other child too because they were just as bad. And then now the court agreed to let the person that hired me be the sole successor trustee. Then she started getting stuff done.
Wow.
So I've never known it to work.
I bet that just boiled the blood even harder.
Yeah, I mean.
But it is what it is.
One of them tried to contest it, but they didn't have much staying power. They probably went and talked to somebody and said, you know, if you weren't such a jerk, you might have a case. I mean, even a door attorney might say something like, why didn't you agree? I mean, you know, you can stand to inherit some of this property. Why would you want it just to be dilapidated, you know? Yeah. Anyway, so we got through the whole thing. We distributed all the property, and we fixed the roof and got everything done. But again, my point is, when you have this unanimous authority, I just have never seen it work well. It's possible it could, but I think it's a roll of the dice. So I would stick with either a consecutive order, or if you're going to have co-trustees, independent authority to act.
Yeah,
And I wouldn't name 5 or 6 either. I think it's kind of wild.
I run into that a lot, and it's in usually a will situation where we have co-executors, and we want to sell a piece of property. You know, they both have to sign things. You know, it's
Slows it down.
slows it down, and then if they happen not to agree, one of them wants one thing, one another. Here we go.
Now you need a tiebreaker.
Needed tiebreaker.
If you had 3 kids and put in a unanimous vote, you'd have one. But if you had 2, now what are you going to do?
Yeah, it does cause a problem, and it can be easily addressed if you think about it ahead of time, I guess. And,
That's right.
And like you said, know the pitfalls and the options that could be out there, and for to talk with someone who's gone through it and or knows the process.
Well, it's it is the forethought, and like I said, you might not think about that, but if during this vision meeting we have when we talk about it, I'll bring that stuff up to you. And again, I'm not going to browbeat you into doing one thing or the other. I'm just going to tell you what I think is, if you want, a lot of people say, I just want it to be as easy as possible for my kids.
Yes.
If easy is your goal, then we don't want unanimous authority. We want a
Right.
successorship. That sort of thing. So I'm an advisor.
Do you find that
advisory role?
Do you find that people have a hard time emotionally thinking that they're choosing one child over another, or
I do.
That's probably some of the angst about
Good
it.
question. I would like to address that too.
Yeah.
It's a very good question, and before I get into that, I don't want you to throw me off too much. You still haven't changed your clock from last week.
Oh, we got to wake the roosters up.
I was gonna say I'm not supposed to start this show for 30 minutes according to that truck.
Well, it's 8:31. We're good. We're good.
I think I can adjust in my mind. If I can't add or subtract by 1, they're gonna lock me up. So you talk about emotional, but let's say you have 3 children.
Yeah.
And you need to name a successor trustee, like we just talked about,
Right.
right? And they say, well, I want to be fair. I want to be fair to them. And, so I want to make them all. If I name child 1 the successor trustee, I'm worried child 2 or 3 will feel slighted.
Yeah.
Here's my response to that. Maybe you don't put too much weight on that being slighted, because let's just say the trust says all 3 children get a third.
Yes.
Right? Well, child number 1 is a successor trustee, and he gets a third.
Yeah.
And he has a job to do.
Yeah.
Child 2 and 3 get a third, and they don't have a job to do.
Yeah.
They don't have to do anything about it to get their third. They just get it.
Yeah.
So, you're actually encumbering child 1, not doing them a favor. The other 2, once they realize that what would be involved to be the successor trustee as well, and they still don't get any more for it, might reconsider feeling slighted by doing that. You know what I mean?
Yeah. That's a thought.
But some people, even if they do that, I always tell them, I usually can convince them that the independent authority is a better way to do it. But again, that's right. Some people feel that they don't want the other children being mad if they pick one for that duty.
Yeah. Yeah. I can see that.
And I have had heirs tell me, you know what, she can do it. I don't want it. I don't want the job.
Oh, yeah.
They can do it.
Yeah.
I haven't got the patience to do it. I haven't got time to do it. I'll pretty much, I have no objection to them doing it.
Right.
That's typical too. So, but yeah, people have that thought about being fair, and they have that thought about being fair with distribution of property too.
Oh yeah.
And I tell them, I say, fair is what you think it is, right?
Right.
Fair is not you have 3 kids, you got to divide everyone by 3. That's not necessarily fair. I run into certain situations where people will say, when my son wanted to buy a down payment on his house, I loaned him I gave him $50,000 to do that. And it wasn't a loan, I just gave it to him. But I don't want it to be, but I want that to be considered an early inheritance. We
Yeah.
call that an offset. We can do that.
Yeah.
And what we do is we say, okay, when we get to distributing the property, you got 3 children, we're going to distribute everything divided by 2 until those 2 have $50,000 worth.
Right.
Then we're going to start dividing it by 3. So we're taking into account that this person already got $50,000 of inheritance. So we're not going to divide by 3 until the other 2 get to that level. We do that often. And other people will say, my son, he's very successful. He went to school and he got a good career and he's doing better now. He doesn't need any of my inheritance. So I'm going to heavily weigh it in favor of some of the other ones that may need it. So at the reading of a trust or a will like that, and you're leaving nothing or very little to a child and much more to others, the first thought on the paper might be not fair.
Yeah.
But it's 100% fair in their mind because they don't need it. You know, I mean, and they don't complain about not getting it. You know?
Right.
And I've actually had people say, "Don't worry about giving me anything. Give it to my sister. She struggles a little more than I do." So
Yeah.
so you know, fair is what you, the maker of the trust, think is fair.
Yeah. Yeah.
That's the beauty of a trust. I mean, there's no rules. You are writing the rules. I've said that many times.
Oh yeah.
There's no rule that says you have to be fair. Actually, I under the law, I can confidently say that you can disinherit a child. Now,
Yes.
You can't disinherit a spouse, but you can disinherit a child.
Yeah. I've
You don't
I've
have
seen it
to
happen.
legally.
I've seen it happen.
Yeah,
I know,
see it happen
I know
a
that.
lot. And you don't have to do that. I mean, spouse is a little different. And even that's just because we have that action called elective share, where you can
Right.
sue to get at least 40% of the estate. But I don't ever run into a spouse wanting to disinherit a spouse. If that's the case, get a divorce.
Yeah.
Then you don't have to leave anything.
Which is a whole nother can of worms.
Which,
by the
yeah,
way.
right. But like again, fairness is what you want to do, and that's I tell people, you know, you're sitting at my conference table, and I'm on one side and they're on the other, and behind me is my whiteboard, so that if I need to use it, and I tell people that, hey, on my side of the table, it's all about you, what you want. You're the makers of this trust. What you want is what I want. You know, if you what you want is what the kids want, that's great. But if it's not, it's still what's important to me is what the maker of the trust wants, and that's what I'll make the trust say. You know?
Yeah.
And a lot of times when people talk about that, I would like to say to them, you don't even have to explain to me why you're. In other words, somebody might say, well, I'm not going to leave this child anything, and I'll be glad to do that. But I usually ask about it, not because I'm being nosy, but I can usually spitball some ideas around why they're doing that.
Yeah.
Now, if the answer is, well, we're just estranged, he doesn't come around anymore, he married somebody, he's more with their family than ours, and we just are hurt by that, so we just don't want to leave anything.
Yeah.
Well, then okay, there's nothing else to talk about. Now, what if you say, okay, I don't want to leave him anything because he's got a bit of a drug problem, and I know if I leave him money, he's going to just kill himself.
Yeah.
You know what I mean? With that money. Okay, now let's talk about some ideas and say, well, it sounds like you love the child, you just don't love the habit, right?
Right.
You love the sinner, not the sin.
Right, right.
But we can do something here. We can leave him his inheritance, but we can control how he gets it so it doesn't exasperate the problem or even be used for the problem. You know,
Right.
So now when I ask about why, I'm trying to see if there's some suggestions I can make, because when they find out that they're disinheriting them, but they don't want to disinherit them. They just disinherit him because of what they're afraid he'll do with the money.
Yeah. Yeah.
How about leave him his share, but we'll put it in a trust with an independent person as the trustee over it that will control it.
Right.
It would work. Here's how it might work.
Right.
That person could go to the trustee and says, "I need $5,000 out of my trust."
Yeah.
The independent trustee would say, "What for?" And he'd say, "I'm not going to tell you." And the trustee would say, "Then I'm not going to give it to you."
Yeah.
But if you said, "I need $5,000," he says, "What for?" "Well, I'm trying to turn around. I've enrolled in maybe a rehab program,
Yeah.
or I'm taking classes at Columbia State, and I'm going to try and finish
Yeah.
my degree or something. Here's the bill, and it's $5,000." Now that trustee would say, "All right, that's a non-drug or alcohol related problem, and that's something if the trustors were still alive would probably support, right?"
Yeah, yeah.
And so okay, we'll do that. Now I'm not going to give you the $5,000. Give me the bill, and I'll pay it.
Right.
You know, but you see how
You got to be smart with
you
it.
see how you keep the person from using the money to hurt themselves.
Sure.
But it's available if you can get them to reach the point where they want to help themselves.
Well, that brings up another thought. Maybe it's not a drug problem. What about an underage beneficiary to a trust?
Yeah, you can have underage beneficiaries. They just can't take until they're of age.
Yeah. So how would that play out?
I would say a child can't. It's not that a child can't inherit. They just can't get it till they're, by law, 18 years old.
Okay.
Now
Can you change that number?
you can, but you can't go lower.
Okay.
You can make, and often do. And the reason is, myself included, I can't think of anybody that wants an 18-year-old child getting a big inheritance. Right?
Yeah. I'm of the same mind frame. 18. You know, 18 is.
25 is a common number people pick.
Yeah.
So yeah, there's a lot to that. There's a whole section in the trust that talks about underage or incapacitated beneficiaries.
Yeah.
So you'd have the same concern with an underage person as you do with somebody that can't control their money and they're incapacitated.
Right.
And so, and we don't know. Somebody might say, "Well, all my kids are adult. I don't have to worry about that." Well, maybe not so. If one of your children pass away and you say, "I want it to go," what they call persterpes, go to their descendants.
Yeah.
When things like that happen, we're very likely to run into a minor.
Yeah.
So, because it just kind of goes from there.
Yeah.
Dilutes from there.
Yeah.
But if we do run into a minor, then the successor trustee can either be or appoint a property guardian over that person. And that's typically a parent if it's available, right?
Right.
So here's your inheritance. I'm going to distribute it to your dad. Your dad's is a property guardian. He has a duty of holding it until you become whatever age the trust says. So let's say it says 25.
Yeah.
At 25, you get it. Or
Yeah.
you put other terms and conditions on it. But let's just make it simple and say you don't get it till you're 25, and then
Right.
you get it at 25.
Right.
And so that's all in the trust. That's how we deal with that. Somebody has to be in charge of that money until they become of age. Okay.
Yeah.
And so, and it can be money or property or something like that. Now, when you say, I don't want them to get it till 25, in that gap between 18 and 25, certain things happen like college or marriage or trying to buy your first home, stuff like that. Okay?
Right.
Now, my trust always have the language that successor trustee has certain discretion. And discretion they can distribute before the age that we want, before the age 25, if it's for health, education, maintenance, or support. Those are called ascertainable standards, and they're kind of like the necessities. So, if the person's 18 and they get 20 years old and they want to go to college, and they need help paying the college bill, right?
Mm-hmm.
So they go to the successor trustee and say, I know I'm not 25 yet, but I need some money to go to college. Now, the trust would say, we can allow for education. And when you think about it, the logic is there. If the parents were still alive, they'd say, well, sure, I'll help you with a college education.
Sure.
You know what I mean?
Yeah.
And so, or if you had a medical bill for some reason,
Yeah.
and you want to pay it, they'd say, well, sure, I'll help you with that if you're stuck paying it. So health, education, maintenance, support, and you can even pigeonhole certain things in there, like if somebody's going to college but they need a car to commute.
Right.
Well, that's support. Just to make things happen. So you can invade that before that if it falls into those necessities pretty much. So,
Yeah. Interesting.
and then at 25 you give it to them. Or some people say you get a third of it at 25, a third of it at 30, and a third at 35, or whatever ages you want to make. There's all kind of ways to divvy it out like that. But we were talking about minors. And so if you are a minor,
Right.
if somebody else is going to hold it, you can't get it before you're 18 by law.
Right.
That's under our Uniform Gifts to Minors Act. But at 18 you can get it. And some people say, yeah, at 18 I'm going to give it to them.
Yeah.
But most people think, 18-year-olds these days. I mean, it was different when we were 18. I mean,
Yeah.
and I know that sounds like somebody's going to say, oh, well, every generation says
Yeah.
that, right? But I think it truly was. I mean,
I'm a believer of that too.
I mean, you and I were probably working or doing something at age 16.
Yeah.
I was a golf caddy at age 15 because nobody would hire me because I was only 15 years old. Or
Yeah.
doing odd jobs like I was in Pennsylvania shoveling snow, mowing grass.
Yeah.
You couldn't tie me down. I spent more time trying to get a job than the jobs I actually worked.
I did the same thing. I started working before I could drive. I had to be hauled here and there. Of course, we hauled hay when we was doing nothing else, and I worked for little jobs everywhere.
Nowadays, you got restaurants that hardly stay open because they can't get anybody to come and get hired. But hey, so it's different. And people, statistically, people really don't mature till 25, 26. I mean, I had one of my children's like that. I was worried about one of my kids, and somewhere around 26 years old, it just seemed like the light just went off.
Yeah.
And it's just this drastic change, and it's like, oh, thank gosh, this guy, he gets it now.
Yeah.
He finally gets it. Up till then, I thought,
A proud moment.
where's this thought process coming from? I don't understand. But it clicked, and
It struck me the successor trustee, who's in charge of seeing that the trust is managed.
sometimes we'll call that person the after death trustee. It's a little more descriptive, but a little
That's a
more.
very responsible position.
It is.
Because if you have to make those kind of decisions to make an allowance for this young person, you got to have some judgment about that.
Well, you have to have some guidance, and that's what we put in. And like I said, that's exactly what that health, education, maintenance, support standard is. That's a little guidance on what they can do.
Yeah.
It's not an absolute no. Until that 25th birthday hits, you don't get squat.
Yeah.
It's not an absolute no. There's some discretion because it's for the child.
Right.
If you give it to them at 18, they have their own money to go to college. But the problem is, you give it to them at 18, they may blow it. Then when they want to go to college, they don't have it.
Yeah.
And now it's like, okay, the whole plan was to provide for the child and give them a head start on something.
Yeah.
And the things I see people like to use their money for are things like an education,
Yeah.
down payment on a new home.
Yeah.
And that kind of cripples a young couple when they first start out these days.
Sure,
And
sure.
now more than ever, so they need some help there. Or, some kids are entrepreneurs and they like to start their own business, but it takes a little bit of money to start a business.
Yeah.
Most of them. And so it's that's something they might somebody, the trustor would think, well, that's a good head start on something, and I
Yeah.
wouldn't mind them using their inheritance for it.
Yeah.
The things people don't like your kids using inheritance for are squandering, foolish things, or paying off your debt. You know,
Yeah.
I like to leave my inheritance to my 3 kids, but if they got a lawsuit or a creditor nipping at their heels, I don't really want to use the inheritance to get out from under that. I mean, they got themselves into that, they should get themselves out of that.
Yeah.
I'd rather it be used for a good start than to just pay off their debt. You know what I mean? I think you learn a lot of lessons by paying off your own debt.
Yeah.
And so you might, I don't want that to be what it's for, so. Anyway, but you can give as much guidance on that as possible. We give a lot of guidance when it's special needs and stuff like that, because, because people, if somebody can work, when you have a special needs person, there's all kind of functionality that people can have. You can be
Right.
100%, 0% functional, or 20%, or 50, or 75. And if you have some functional ability, you can do certain things.
Right.
And you can earn money. And it's a self-esteem thing as well as anything else. And so you want to encourage all that. So there's a lot of decisions to be made with special needs trust. And sometimes there's better to have a professional special needs trustee, because they mess with those laws relatively often, and you need to be willing to deal with the changes. So, but yeah, the successor trustee, any trusteeship, is a pretty serious role. It's called a fiduciary duty. A fiduciary duty means whatever you do has to always be in the best interest of the principal.
Yeah.
Now, you got a fiduciary as an agent, a power of attorney, which is a thing you do during life.
Right.
And, I get these old timers that say, I'm not going to do a power of attorney because I don't want to sign my kid and have him spend all my money.
Yeah.
And it doesn't work that way. It's a fiduciary duty. Could a kid do that? Possibly, if he went rogue.
Yeah.
But, if anybody else brought that action to the court would remove him in a heartbeat.
Yeah.
Just remove him and punish him pretty bad. That's can be a criminal offense to just take your mom's money and just buy yourself a new car, or pay yourself for a Hawaiian cruise or something like that. It's always got to be in the best interest of the principal. So I always describe a fiduciary duty like this. It lets you, if you stand, you'll never go wrong if you do this. If you stand in the shoes of the principal, and you do what they could do, if you do what they would do if they could do it.
Yes.
So somebody's incapacitated. They had a stroke and they just can't do anything, and the light bill is due.
Yeah.
I mean, if they were not incapacitated, would they pay the light bill like they've been doing for the last 50 years? The answer is yes. So it's okay to pay that bill. You're satisfying a fiduciary duty.
Yeah.
Is it a fiduciary duty to send $50,000 in their money to some guy in Zimbabwe that sent an email saying, "Hey man, help me out"? You know what I mean? The answer is no. That would not be right. It's not a hard standard. It's not a hard test. I like to give it that way. You are them doing what they would do if they could do it.
Yeah. This is a very responsible position.
And it's real common sense too. It's not
Yeah.
heavy duty logic. I mean, it's real common sense. You just do the stuff that needs to be done, and if Daddy would have done that, then it's okay for you to do it.
Right. Yeah.
I mean, at least now it's justifiable,
Right.
because that's what Dad did. Maybe
Right.
there were some donations to be made. Suppose Dad made donations all the time to something like the American Legion, like we're having our seminar at,
Right.
or the Wounded Warrior Foundation because he was a vet, or something that they were passionate about.
Yeah.
Even Humane Society for pet people, if they're passionate about it, and they made donations every year or often, and you as the power of attorney or successor trustee, if it says in there to leave money to the Humane Society, and it's okay to do that, because somebody, it has nothing to do with somebody coming up to you and saying, well, that's a stupid charity, you're wasting your money giving it to them.
Right.
It has nothing to do with that. It has everything to do with the trustor's intent.
Yeah.
If that's what they wanted to do, I mean, it's okay. One good thing about a free country is you're free to do stupid things.
Yeah.
You're free to give money away to stupid charities if you want, because they're stupid to some people, but they're very, very valuable and worthwhile to others.
Yeah.
So you don't second guess their intent. That's just what they wanted to do.
Right.
So it's not hard to follow if you just use a lot of common sense.
It's pretty amazing what I've learned, in the weeks and weeks that we've had of talking, how much you can set up this system that perpetuates after you're gone.
Yeah.
To do what you would have done, which is what this is about.
Yeah. I mean, my own experience with this death in my family, those folks did a nice trust plan.
Yeah.
And things were, for the most part, going very well. Although the individual that passed was supposed to do something with a couple of bank accounts. And I remember talking to him on many occasions afterward, and actually reached a point where he told me it had been done.
Yeah.
And so I stopped bugging him about it.
Yeah.
Now that we're here, we find out it hadn't been. He just bamboozled
Just
me.
neglected. He neglected to do it.
He bamboozled me, right? And said he did it when he didn't. And it's not really a big issue, but it's something that has to be dealt with.
Just makes it a little cumbersome.
It's a couple of accounts that are just in his name individually.
Yeah.
Which would, it takes 5 minutes to change the ownership over to the trust. And many of the other stuff, almost all the other stuff was. So
Yeah.
I'm not sure what happened or why it happened, but it did. We'll deal with it. But I mean, it's not that big a deal, but we'll deal with it.
Wow.
So, it is a grand thing to plan ahead of time. You can sure save your heirs a lot of heartache,
Absolutely.
a lot of headache. And that's kind of what it's all about. So other than our asset protection trust, which falls in this category too, but a lot of times when you do planning, you're not really doing it for yourself. I mean, you're kind of doing it for the people you love, really.
Yeah.
I can argue that what you're doing for yourself is this peace of mind concept, that you've
Yes.
done it and and you can rest easy that they're taken care of. Okay?
Yeah.
There's that part that's for you. But for the most part, the people that are going to enjoy the simplicity and the ease and the lack of hassle are your heirs, based on what you do.
Correct.
So if you write a will, which I'm a big fan of wills because they have to go through probate. So if you write a will and you name 5 people co-executors with unanimous authority, and you're very vague and ambiguous on what property goes to who, you're handing a nightmare to your children. Just an absolute nightmare. They will not be happy about it.
Yeah.
But if you plan and put stuff into a trust, and you put in the trust, how you want the property. You can be very specific, how you want the property distributed. You name people with a consecutive successor trusteeship, where there's no, that sort of thing. And it goes like a well-oiled machine, I often say my best client, I have seminars and I talk about this, that the trust goes smooth, and it's better than a will, and it's a great tool. My best client is people that walk in and say, hey, mom and dad had a trust, we administered, it went like a well-oiled machine, save the sales pitch, Mr. Stan, we want a trust, because we've seen it work. I have that happen, and that's the best client in the world, because they've seen it happen. They've seen how the thing gets administered, and they know that's what's gonna happen when they pass away. And you just have to set it up. All you have to really do is come to the seminar, see what floats your boat, and if something does, we'll talk about it. I'll tell you what you have to do. The time commitment going forward is very small.
Oh yeah.
I say this a lot too. Most people don't do this kind of stuff and procrastinate. And I really think the reason why is they don't know what to do.
Yeah.
They say, well, I thought all I could do is a will and have to leave everything equal, and I'm not sure I want to do that. So if that's the only thing I can do, and I'm not sure I want to do it, I just kind of don't do anything.
Yeah.
But I guarantee whatever you have in mind, you can come to me and say, hey, I got the most bizarre distribution scheme that you've probably ever heard.
Yeah.
And I'm going to say, lay it on me, because I'll bet you it's not. And whatever it is, even if it is the most bizarre thing I've ever heard, we can reduce it to the language that needs to be in the trust and make it happen.
Yeah. Yeah.
I've had some pretty odd requests, and that's okay. That's okay. People sometimes get embarrassed and I say, don't be embarrassed. Tell me what you want. Like I said, my side of the table is what you want.
Yeah.
The legislature has written into the law the language that the trustor's intent is paramount.
Yeah.
Which means that's what we'll support. As ridiculous as it may sound to most people, or even the court, if that was their intent, that's what they'll enforce.
Yeah.
So, if you write in there that, these tiny little things when you want it distributed, or when you want it distributed, or the case I often mention was that one case where the mom said, if the son is not married at the time of my death, he gets his inheritance.
Yeah.
If he is married to the current person he's married to when I wrote this, then it has to go in the trust, and his sister controls it. Because read between the lines, right? She saw a gold digger in the family and didn't want to go that route. And court went the case. He was complaining it violates his right to own property, and the court said no, it does not. The trustor's intent is paramount, and that's what she wanted. Unfortunately for you, you were married to the person that triggered the clause, and that's what we'll uphold. It goes into trust. Your sister controls it. Go fish.
That sounds like a bitter pill.
It was, and you can see what mom's concern was. But here's the important thing: it was mom's concern. It wasn't the son's concern.
Yeah.
It certainly wasn't his wife's concern.
You know, I can imagine though the son thinking that he'd overcome that, but he couldn't.
No, he could not. He took it to court.
That's the power of the trust.
That's exactly right. Exactly. I mean, you don't want to go to court, but what these court cases show us that how powerful they are. So if that happened today, somebody says, well, I'm going to take this to court and sue it, and they hire an attorney, it was worth their salt, that researched a little bit, they go to him and say, look, you have like no chance of winning, so there's no sense going to court and spending all that time, energy, and effort. Or you have an attorney who just says, yeah, let's go to that, just be sure to pay me for every hour.
Just pay me for every hour.
And if it doesn't work, I'm just going to say, sorry, no, we just didn't win that one. I don't know how. I'm just saying, you can kind of know how things are going to work because we've seen how it worked in the past. So it's a great tool. It's what got me into this business, and I just love what I do because everybody's different.
Yeah.
Everybody's different. So.
Yeah.
Well, it looks like we're
good and interesting show this morning.
We only have an hour and 5 minutes to go.
Well, we'll whittle it down to 5. How about that?
That's right. We'll talk about the seminar again. It's coming up real close. It's a week from tomorrow, which will be March the 22nd. That is a week from tomorrow.
I would certainly encourage you to go to the seminar.
Yeah. And it's we call it Wills, Trust in the Nursing Home, because that's kind of what we talk about. And if you're concerned about this high cost of long-term care, it's definitely a good one to come to. If you just want to hear a little bit about will versus trust, we talk about that, and how the trust solves certain problems. It's very educational. And so we do it at 10 o'clock in the morning on Saturdays. And it's, like I said, it's over at the American Legion in Pulaski, Tennessee. That's up on the hill there, a couple blocks off the square. The actual address is 425 Legion Drive, so if you want to put that in your GPS, it'll get you there in Pulaski. Come to that, and if you have questions, and I know you do, write them down, bring them with you, okay? And if you develop a question during the presentation, write it down. Because at the end of the presentation, which is all I ask, is don't shout it out in the middle, let's wait till the end, and I open up a very comprehensive question and answer period, and I will stay as long as I need to stay until the last question's answered. So don't come to the seminar and leave it with a question unanswered. Ask me. Take advantage of my time. I'm more than happy to do that. And people do. I mean, it goes on for a while, question and answer.
Yeah.
And you can really benefit from other people's questions.
Yeah.
Somebody asks questions, so yeah, I thought about that too, man. What's the answer to that?
Yeah, absolutely.
It happens all the time. So come to that. If you want to come to it, give my office a call at the Pierchoski Estate Law, Pierchoski Elder Law. My telephone number is 931-363-7222. Or you can go to my website. It's easy to get to. It's estateplanstand.com. There you can maybe RSVP by email or get the phone number and call.
Sure.
Or you can look at my calendar and see where I'm going to be.
Yeah.
It escapes me where we do them about every other month, and I can't think of where it's going to be here in May, but it's already scheduled. But I'll bring it up next week. But we're here every Friday morning from 8 to 9.
Yep.
It's an interactive call. I think we forgot to give the phone number.
Well, we had a lot to talk about. We had a lot to talk about.
Gee, it seems like somebody should have called us
Yeah.
to say, hey, would you please give the phone number so we can call? Now that would be a bamboozle.
No, bamboozle.
Maybe we bamboozle them by not giving the number.
Don't forget to RSVP and get to the seminar. 363-7222 there, estateplanstand.com. And of course, Stan's office is in the historic public square there in Pulaski, Tennessee. Beautiful square, active square.
It is.
A lot going on there.
And this weekend, I don't know how the weather's going to impact it on tomorrow night, but or tomorrow's matinee. But is the last weekend they're playing Finding Nemo kids version.
Oh, I bet that's been a lot of fun.
It's a short show, about 35 minutes long, but it's all kids, like 51 of them involved.
Oh my goodness! I bet they've had a ball doing that.
Oh yeah. And listen, for the seminar, the RSVP is a very loose process. If at the last minute you decide, you know what, let's go to that seminar. Saturday morning you get up at 8 o'clock and you say, you know what, let's just go to that seminar. Just come on and walk in. It's okay. The head count is just pretty loosey-goosey.
Right.
Trying to
Be at the American Legion,
Yep.
and that date again is the 22nd.
22nd, a week from tomorrow.
Week from tomorrow.
Maybe
Maybe the weather will be nice.
I think it will. I think we'll probably use up our bad weather tomorrow.
Yeah, we're going to use up the bad weather tomorrow. Yeah, that's right.
Hopefully it won't be too bad.
That's right. Estate Plan Stan, everybody, and he's here every Friday. And of course, I did find out that the Facebook feed was working while we did this.
Oh, good.
So the Facebook feed was working, and so we got that up and running. And
if
so
anybody watches it on Facebook feed, give us a call and tell us how we look.
yeah,
Do we
yeah,
look
that,
okay?
that actually ended up kind of working there for us, even after all the struggles we've had this week. So
I like the concept of visual radio. I think it's
yeah,
pretty cool.
it's a lot of fun. We've had fun with it, and of course, interesting and dynamic conversation always concerning wills, trust, estate planning, and bulletproof estate planning.
That's right.
All right, Stan, good to see you, buddy. We're out of time. We got to roll.
Always a pleasure, Jeff.
Thank you. Next time.
Phone call. I'm Dave Anthony, Fox News. The president just posted on Tuesday.
Good timing.
He had a very good, productive discussion yesterday with Russian leaders.